Okay.
Well, welcome everybody to our second session this morning on contract management services. Today's speaker is Brian Gamsey, who is an attorney in our corporate technology and tech transactions practice groups. Brian graduated from North Carolina School of Law. He was a staff member of the North Carolina Law Review, executive board member of the UNC Law Pro Bono program, president of the Entrepreneurial Law Association, a Dean's Fellow, and a member of the Davis Society. Very smart guy, very entrepreneurial. While he was at UNC, Brian also worked with the Carolina Angel Network, CAN, to do sourcing, screening, and conducting diligence on venture capital investments in UNC-affiliated companies. So we're very lucky to have him with our law firm, and we're lucky to have him today as our presenter and speaker. He will give you a lot of good information. Thank you, Brian.
Thank you, Ann. I really appreciate that introduction. And good morning, everyone. I really appreciate you joining me today for this webinar. Today, we're going to be talking about how to protect your assets when negotiating your tech contracts. Feel free throughout the presentation to ask questions as I'm going through the slides in the chat feature. Hopefully I will see them, and if I do, I will pause to get attention. Feel free to unmute yourself and ask a question and interrupt at any time if you'd like as well. I want this to be as interactive as possible, and hopefully we can all get a lot out of this today. Next slide, please. So to begin, I want to share a cautionary tale. In 2006, a new startup was negotiating a contract with a distributor that had a high visibility platform, which would make this startup's product available to a large consumer base. The contract was going to be a big revenue generator for the startup. Generating revenues at this level was the first step in getting put on the map as a real player in the industry. However, there was a catch. The distributor required ownership of all the IP created in order to close the deal. The startup was at a crossroads. Was the ability to have access to these customers and the cash that came with them worth assigning over all the IP rights? The startup thought the revenue and exposure was more valuable than owning their IP, and the product turned out to be a huge success. The startup tried to reacquire IP ownership for years and years after the initial contract, but to no avail. And eventually there was a $300 million exit for the distributor, with the vast majority of the valuation stemming from the startup's IP. And the creators of the IP did not see a single penny from the exit because the IP rights and ownership were given up. Does anyone know who this startup is? Next slide, please. The startup, of course, is Taylor Swift. While T-Swift could shake it off and ended up landing on her feet, today I'll be discussing with you what terms to make sure appear in your tech contract so you can avoid losing out when your exit arrives. Next slide. It may seem like an obvious statement that your contracts matter, but why it matters and what is most important to negotiate is far more nuanced. Most importantly, when you go to raise money or sell your company, somebody like me be looking at all of your contracts to assess the risk. We frequently see our buy-side clients walk away from acquisitions based on single contracts entered early in the life of the sellers that put the company's IP at risk of not actually being owned by the seller. So how do you mitigate this risk? If possible, offers start the negotiation with your own paper, which is a contract that you have drafted. And this is the first practical point I'm going to be making today. Start with your own paper. However, as a startup, you're likely to be contracting with a party that has more leverage than you. So they're very likely to suggest highly favorable terms to you and may require you to start with their paper. If that happens and the other party gives you their paper, don't worry. They generally will expect these terms to be negotiated, so you should not automatically assume you have to sign what they put in front of you. I've never heard of a company requesting negotiating terms leading to a deal falling apart. The worst they can do is say no. Next slide, please. So here's a roadmap of what we'll be going over today. It's a well-drafted contract, also provides clarity on the pertinent business issues as the relationship moves along and allows for smoother relationship management. Various components of the agreements deal with allocating risk between the parties. But today, what we'll be focused on is drafting contracts to protect your company's assets, especially with regard to IP and confidential information. You all have different companies with different issues and concerns, so I'm going to cover the most important information protecting your assets at a high level so you can begin thinking about these things as they apply to your company. The four most important provisions to focus on when thinking about protecting your assets are ownership and license rights, confidentiality, assignment restrictions, and most favored customers. As a practical point, these are the big four of protecting your assets. Focus on these four if you can't focus on any other aspects of, or negotiate any other aspects of your agreement. Let's jump into ownership and license rights. Next slide, please. Practical point here, just saying you own it doesn't mean you actually own it. It's because legal ownership of intellectual property is different than most other types of assets. For example, if you hire someone to build you a bedroom set and the contract says, upon its creation, the company is the sole and exclusive owner of the bedroom set that the contractor built under this agreement, then the company automatically owns the bedroom set. However, if you use that same contract, but instead of a bedroom set, this time the person built you an app for your company, and the contract says, upon its creation, the company will be the sole and exclusive property of the company that the contractor built under this agreement. Then the company does not automatically own the app. I know this seems counterintuitive. If a contract says that the company owns the app, why doesn't the company own the app? The reason is because of the US Copyright Act. The US Copyright Act bestows certain rights onto the creator of the intellectual property automatically upon the creation of that intellectual property. And to transfer legal title or to actually own the app, you must have certain language in your agreement. So what words should you look for to ensure that you do own the IP rights and developments being created for you? The two most important are assign and work made for hire. Now, this is not an exhaustive list, and any provision discussing or referencing ownership should be scrutinized closely. But I have witnessed multiple M&A deals fall apart over these words. To own legal title and copyrights in any intellectual property created for you, there must be a present tense assignment of those rights. Unfortunately, the language we use generally in contracts to denote an obligation, such as will, shall, agree to, may cause problems with interpretation because these terms are frequently used in common English to denote a future obligation rather than a contemporaneous act. I will go to the store means I haven't gone to the store yet. The combination of the IP not existing at the time of the assignment together with contract language that may suggest a future obligation can result in IP assignment language that does not actually assign the IP. Another agreement executed in the future then becomes necessary to receive title to this IP. Our experiences have been that those future agreements are not regularly obtained. This can create real issues associated with the company's ownership of its IP. Cases I've researched make clear that no particular magic language is required. Courts seek to determine whether the language manifests a present intention to assign IP rights or whether the language in the agreement is to assign in the future. The goal is to determine whether the agreement manifests a present intent to assign. Having the work assign is a magic word that must be included to transfer the ownership of the copyrights. Going back to our earlier example, let's say the contract for the app now says, contractor hereby assigns to the company all right and title and interest to the app. This would be sufficient for the company to own the copyrights in that app because it manifests a present intention to assign IP rights. Under the US Copyright Act, in certain contexts, copyrights vest immediately upon the creation of the copyrightable works. Where applicable, the work made for hire doctrine shifts the vesting of the copyrights from vesting into the creator to the company. In an employer-employee relationship, the work made for hire doctrine will also apply to the copyrights created by an employee working for its employer within the scope of its job duties. The work made for hire doctrine, however, only applies to contracts in a very limited number of contractors in a very limited number of contexts and does not apply to the creation of software. Going back to our earlier example, if the agreement with the contractor now says the app and all intellectual property rights in the app will be the sole exclusive property of the company and will be deemed to be a work made for hire as defined in Section 101, Title 17 of the United States Code. It is still very unlikely the work made for hire language in your agreement will grant ownership of the copyrights in the app to the company. Only a manifestation of a present intent to assign ownership of the app and its related copyrights will transfer legal title from the contract developed to the buyer. Everything I just explained is exactly what you need if you're getting someone to create IP for you, and hopefully you've taken away that these words should be used with intention. However, there are certain situations where the exact opposite is true, and you want to avoid having these words in your agreements. For example, if you're providing SaaS services, there should not be any work for hire assignment language. There shouldn't be any expectation of owning your product. So if the assignment language appears in your SaaS agreement, strike it immediately. In that case, the contract may say that you own the SaaS product, but if you assign your rights to it or provide the services under the work for hire doctrine, you won't actually own it. Remember, when it's time for you to get funds raised or sell your company, the value is going to be created in owning what you think you own. It is likely worth walking away from a potential customer if that customer insists on having assignment or work for hire language in the SaaS product you are providing. Speaking of SaaS agreements, let's transition our conversation to license rights. Next slide, please. Practical point, the wrong license can give up practical ownership. For example, let's say you have a SaaS offering. You, as the provider, are licensing that SaaS product to a customer, and the contract says, provider grants to company an exclusive, perpetual, irrevocable, worldwide license to copy, market, sell, create derivative works of, distribute, install, perform, and display the licensed software. The words exclusive, perpetual, and irrevocable, if you see any of those words in your license agreement that you're giving out to a customer, it should raise a red flag. If you see all three of those words together, exclusive, perpetual, irrevocable, big flashing lights should go off. If you grant an exclusive, perpetual, irrevocable license to a customer, you would still technically have ownership of the product. However, the company getting the exclusive license has singular permission to exploit the intellectual property in question forever, and you cannot rescind that permission. It is possible that no entity, including the party granting the license, that means you, is allowed to use the intellectual property covered by the license. On the other hand, if you're being offered an exclusive, perpetual, irrevocable license, you should probably jump on this opportunity. Again, this is not an exhaustive list and does not always apply. An exclusive agreement may make sense for the right customer if there are specific carve-outs. Perpetual and irrevocable are not infrequent terms found on on-premises deals where there's a single upfront license fee. All terms around a license grant should be closely scrutinized because when a potential investor or acquirer comes knocking on your door, the value placed on IP could be greatly impacted by the wrong license. Next slide, please.
Hey, Brian, Matt, this is Matt. Real quick question on that. Do you recommend that the licenses change between if I'm doing a SaaS deal versus an on-prem software license? How would you recommend that we do those licenses?
Thanks, Matt. Yeah, that's a great question. So the obligations on the parties from a SaaS agreement to an on-premises agreement is different. You do not want to have the same language in regards to a product you will be hosting yourself versus a product that the company will be hosting on its own premises, on its own servers. There are different considerations you need to think about as far as the obligations for security and update and what is provided. So there's a big difference between a SaaS license and an on-premises license, and you want to make sure that that's looked at and thought about prior to granting your license. Thank you for the question, Matt. And John Robinson, I see that there's a long terms of use you just sent to everybody. I'd be happy to take a look at that after the presentation, get back to you with any questions. If you have any specific questions, I'd be happy to answer those as well.
Okay, the upshot is just that this is my attempt to secure the IP of all the data in our system, including any user actions. So essentially, this guarantees our IP so that we can monetize it in the future as we see fit.
Yeah, it looks like, just distilling this down, it looks like the customer, since in a SaaS context, if they're uploading content or materials onto the provider's services, this looks like, John, the way that you guys make sure that you're getting a license from that customer. Is that Brian, is that consistent with how you would recommend that people operate?
Yeah, you want to make sure anytime that customer data is being uploaded, that you have the right and license to use that information in a way so you're not violating the rights of your customer. So yeah, for a customer data license, this makes sure that your services can use that information in a way that's necessary for your services.
Yeah, so basically, what we're doing is we have a B2B sale to communities that serve seniors, and we're interested in capturing as much data as possible about the holistic wellness of seniors. So we have what I consider to be the first of its kind data set on wellness and seniors. And so all end users have to agree to these terms of use. And so this is, potentially quite valuable, what we're collecting, hence the need for this type of permanent, the language that you mentioned. I mean, I use these words that you, those keywords.
Yeah, no, and that's exactly what you're going to want if you want to make sure that you retain ownership of this customer data. Okay, assignment restrictions. So most form agreements put in front of you will restrict your ability to assign your agreement. Practical point, you want to make sure you can assign the agreement in the event of a change of control without consent. This is something we see all the time as a hang up when we're doing diligence. It really can create a scramble for the company when they're in the process of doing a raise or dealing with an acquirer. Restricting your ability to assign from a practical standpoint makes sense, right? If you or your customer, distributor, or license wanted to do business with a different party, then you would have executed an agreement with a different party and not between your two entities. So most form agreements will have a restriction of your ability to assign. However, if an IP license is silent on the assignability by the licensor can generally assign its rights subject to the same considerations as other type of contracts. In absent special circumstances, the license IP, not the licensor's identity, is the main attraction to the license to the licensee. This benefit presumably can be provided by whoever owns the IP. A licensee may have a legitimate objection to the license or transfer of license agreement if the agreement includes obligations to provide personal services that the original licensor is uniquely qualified to provide. In that case, the licensee may be able to argue that the additional obligations the licensor is providing make the contract more than a simple license, but a personal service contract that should not be assignable under the general contract principle laws. Again, this is only if the agreement is silent on assignments. Most parties will be amenable to allowing you to assign the agreement in connection with a change of control. So if that's not initially in the agreement you see, it is certainly worth negotiating. A common misconception in drafting and interpreting contracts, including IP licenses, is that an anti-assignment clause necessarily covers a party's change of control. However, prohibitions on changes of control are likely not implied from a simple anti-assignment clause. Restrictions on changes of control must therefore be addressed separately. Change of control provision gives a party certain rights in connection with other parties' transaction. Although some change of control positions purport to void the transaction, the more direct approach is to provide that a change of control is equivalent to a material breach of the agreement or grounds for termination, or both. So what's a change of control? It can be defined several ways. It can be a transfer of more than 50% of a party's voting stock. It can mean a change in the majority of a party's board members. It can be a replacement of key employees. I've seen it in agreement with a CEO, CFO or COO is changed. That would constitute a change of control. The key here is to see how the term change of control is defined in your license agreement or in your contract agreement. And in the absence of a determinative definition for change of control, it's unclear whether or not certain change of control events would constitute an assignment. So an asset purchase may or may not be a change of control because technically neither the old nor the new licensee changes its ownership or management in the transaction. However, some change of control clauses define the sale of substantially all assets as a change of control. Again, you're going to need to carefully review the language to ensure what is or isn't a change of control. A stock sale may or may not be a change of control depending on how much of the stock the buyer is acquiring and whether the buyer can actually exercise control over the target company. A merger may or may not constitute a change of control on the target company depending on the structure of the merger and the resulting stockholders. As a best practice, we recommend ensuring you have the right to assign in the event of a change of control directly in your agreement, expressly permitting assignment to one or more of the following: to a successor by merger or in connection with a merger, to an acquirer of or in connection with the transfer of all or substantially all of the licensee's assets. In a more licensee favorable form, you may want the assignment to allow in connection with the transfer of assets associated with the license agreement or with a specific license or line of business. You want to have to the acquirer or in the connection with the sale of equity. Change of control is to the change of control to the licensee's affiliates or to certain specific third parties or for a specific person. The other party simply won't allow you to put this specific language allowing for change of control. Some counter proposals include specifying that you will give notice in a change of control but not require consent, or you can try to condition the consent, meaning consent can only be withheld if you're being acquired by a direct competitor, or consent cannot be unreasonably withheld, conditioned, or delayed. Remember, the key here is you want to have as few issues as possible when your company is undergoing diligence from an investor or an acquirer. If you make certain you have the ability to assign your contracts before you get to the diligence stage, you won't have to scramble for signatures when it comes time to close the sale of your company, or even worse, get held hostage by one of your licensors because you can't get their consent without giving them a payout or having to take a haircut on the asking price because you can't get those signatures. So, practical point, make sure you can assign the agreement in the event of a change of control without consent. Next slide, please. Confidentiality. Practical point here, no NDA, no meeting. Protection of confidential corporate information is essential to a company's capacity to develop products, to provide services, to gain economic advantages. Those who wrongfully acquire, misuse, or disclose confidential company information can cause significant damage by impairing or destroying the value of that information. Companies may respond with legal action, but litigation remedies are often costly and inadequate. Not all information is subject to equal protection. NDAs and confidentiality provisions have game-changing power. They have the power because they have the potential to divest your company of its most valuable asset, its intellectual property. Because NDAs can have such an impact on your business, it's important to know their exact terms and not simply accept any agreement without close scrutiny. NDAs are generally used to protect the confidentiality of trade secrets or similar information revealed during communications between parties. And communications, you want to make sure you're covering any sort of communications, whether you're talking to that person face-to-face or over the phone or over Zoom, over email, via text. You want to cover all communications. And it's critical for this purpose. Perhaps of most concern for a startup is an NDA that includes language that severely restricts your IP or allows another party to benefit from your IP. This could be especially ruinous for a startup whose success largely depends on full control and possession of its IP. Suppose you've developed a way for smartphones to carry out routine operations such as texting and browsing using less computing power, effectively extending the battery life. A computer manufacturer has learned of your innovation and suggests a meeting to explore the potential for collaboration. If you don't sign an NDA, then anything you say about your smartphone technology can be used by the manufacturer without consequence. Now, this of course assumes that you don't have a patent for your new smartphone technology, which you would probably want with this hypothetical product. But patents are outside the scope of this webinar. If you have any questions about patents or any other registrable intellectual property, please reach out to me after this presentation so I can connect you with a member of our team that focuses on registrable intellectual property. But remember, as a practical point, no NDA, no meeting. So you read the agreement after you've talked to this manufacturer and they send you over an NDA, and you notice towards the bottom a section pertaining to the definition of confidential information that states something like, any use of the company's energy saving algorithm in the manufacture of a computer is confidential information of our company. Obviously, this would be bad. Your game-changing trade secrets would now be the manufacturer's. And this is why the scope of the definition of confidential information is so important. Preferably, you shouldn't have to mark all confidential information as confidential information, and you want to have carve-outs for certain items that are specifically your confidential information, like in this case, your game-changing product offering. You also may see unilateral protections in the NDA, meaning that you're only required to protect their confidential information. However, if you're providing them with confidential information, they have no rational basis for requiring you to protect theirs and them not to protect yours. You want to make these protections mutuals. Now, an important note about trade secrets. Certain confidential business, financial, and technical information may be subject to protections as trade secrets under state law, in addition to any contractual protections afforded by an NDA. For example, any of the following types of information may be considered trade secrets if certain criteria are met: client lists, marketing plans, pricing and discount structures, business methods, production processes, recipe and chemical formulas, software algorithms, and source code. Additionally, every state offers some trade secret protection, with most having adopted the Uniform Trade Secrets Act in whole or in part. The UTSA states 3 general conditions for protection of information as trade secrets. 1, the information is generally not known or ascertainable outside of the owner's organization and control. 2, the owner derives economic value or business advantage by having exclusive use of this information. And 3, the owner makes reasonable efforts to preserve its secrecy. Now, historically, trade secrets were primarily protected by state law, and there were no broad federal statutory scheme that existed to protect trade secrets, such as there exists for patents, trademarks, and copyrights. However, in 2016, the Defend Trade Secrets Act amended the Economic Espionage Act and created a federal private cause of action for trade secret misappropriation. It authorizes a trade secret owner to file civil action in federal district court alleging trade secret misappropriation related to a product or service used or intended for use in interstate or foreign commerce. The DTSA closely adheres to the definitions of trade secret and misappropriation under the UTSA. It covers misappropriation occurring on or after May 11, 2016, and supplements, but does not preempt state law. Therefore, it's important to know which state law governs your NDA. It is equally important to have anything you consider a trade secret subject to a confidentiality provision or NDA so that it will qualify as a trade secret under law. After you have a firm grasp on what the definition of confidential information is, and that both parties will have to protect that confidential information, you now have to determine how the confidential information can and cannot be used, can and cannot be disclosed, and for how long this obligation of non-use and non-disclosure will last. Many confidentiality agreements limit the disclosure or exchange of confidential information to a specific business person, such as to evaluate a potential marketing arrangement between the parties. A defined business purpose is especially useful as a basis for access and use restrictions in the agreement. For example, confidentiality agreements can restrict disclosure of confidential information to the recipient, its affiliates, and its representatives solely for use in connection with the stated purpose. This will ensure your trade secrets and other confidential information remains protected. In general, recipients of confidential information are subject to an affirmative duty to keep the information confidential and to not disclose it to third parties except as expressly permitted by the agreement. The recipient's duty is often tied to a specific standard of care. For example, the agreement may require the recipient to maintain the confidentiality of the information using the same degree used to protect its own confidential information, but not less than a reasonable degree of care. Recipients should ensure there are appropriate exceptions to the general non-disclosure obligations, including for disclosures to its representatives that have a need to know. Usually in confidentiality agreements, you'll be permitted to disclose your information to certain representatives, but you're going to want that obligation to bound those representatives to the terms of the NDA. You'll also want to make sure there's a carve out as required by law. Confidentiality agreements usually require the recipient to allow disclosure if ordered by a court or legal process without breaching the agreement. One of the biggest issues we see in confidentiality agreements is having the obligations of non-use and non-disclosure run indefinitely. Depending on the state law, this could render the entire agreement unenforceable. We recommend the parties' non-disclosure obligations to be stated to survive for a set period, running for some number of years from the date on which the information is actually disclosed or a number of years after termination of the business relationship, with a carve out that trade secrets remain confidential as long as they remain trade secrets under applicable law. Survival periods of 1 to 5 years are typical. Disclosing parties should ensure they have the rights to return of their confidential information on termination of the confidentiality agreement or at any time upon their request. Recipients often want the option to destroy confidential information instead of returning it to the disclosing party. I just saw a question. What is the client can see the trade secrets as part of the licensing as a SaaS agreement? Should the parties' non-disclosure obligations be incorporated into the software license? Should they begin integrated into the privacy policy and terms of use? Susan, that's a great question. Yes, we typically recommend ensuring that you have confidentiality provisions in your SaaS agreement. This makes sure that your trade secrets are still covered by these confidentiality provisions. You can also draft a NDA and incorporate it by reference into your SaaS agreement, or if the confidentiality is integrated into your privacy policy or terms of use, again, you can incorporate by reference those terms of use or privacy policies, the confidentiality obligations. So that's a very good question. You absolutely, if you are letting clients see trade secrets as part of a license agreement, you want to make sure that you have confidentiality obligations on those customers. Otherwise, you're at risk of losing your trade secret status. So we've discussed the scope of definition of confidential information, unilateral protections, non-use, non-disclosure, rights to disclose, and period of obligations. We're talking about destruction of confidential information. You're going to want the other party to certify in most instances that they have destroyed or returned all confidential informations. This can be difficult sometimes because of the widespread use of automatic network backup programs and email archive systems. So you might want to look for language that allows for archival copies to be retained. All of these non-disclosure agreements and the carve-outs are very fact specific, and you want to make sure you're negotiating this between the parties. Other provisions that are generally included in confidentiality agreements are intellectual property rights. You want to make sure that your intellectual property rights in that confidential information remains yours, and disclaim any license grant under the NDA. Make sure that you're clearly stating that all IP rights remain yours and that there is not an implied or an express license granted just because you're sharing this information. You're also going to want a warranty to disclaim the accuracy and completeness of your confidential information. You also may want to include a no further obligations clause. This will ensure that just because you're having a conversation with the other party, you're not obligated to enter into any transaction beyond the confidentiality agreement itself. Sometimes you want to include a non-solicitation agreement in your NDA that will prohibit you from soliciting or offering employments to one of your employees. These need to be narrowly drafted to avoid potential restraints on trade, and we'll be talking about some restricted covenants in next week's webinar. Well, in our next webinar in a few weeks. So please join us for that webinar to get more information about some of these restricted covenants. You're also going to want to include an equitable relief section. To mitigate the potential consequences of these unauthorized disclosures and confidentiality agreements often include an acknowledgement that a disclosing party is entitled to injunctive relief and not just monetary damages. You'll want to make sure that you aren't excluding any other remedies at law, but that you are explicitly entitled to injunctive relief. Additionally, you may want to have an indemnification so you can get any sort of coverage in the case that you have a third-party claim as a result of a breach of the agreement. And something that's very important is to understand the governing law of the agreements. As I said, state laws may vary on the validity and enforceability of certain provisions in confidentiality agreements. So before entering into this agreements, you want to consult with counsel qualified in the applicable state. So I know that was a lot. It was a lot for me. But the key takeaway here is no NDA, no meeting. Next slide, please. Most favored customer clause, sometimes referred to as a most favored nations provision. This ensures that one party to an agreement receives no worse treatment than given to a third party. Practical point here. If you aren't going to benefit from a most favored customer clause, delete it. On the other hand, if you are going to be the beneficiary of this clause, take it. So what's an example of this? As you see stated, provider warrants that the terms, including the pricing of this agreement, are comparable to or better than the terms, including pricing, offered by provider to any other customer. So this means that every aspect of your contract will be applied in a manner that's at least as favorable as that given to any other third party. Why would you include a most favored customer clause in your agreement? Some reasons are to save time and money on negotiations, right? You've locked into a price. You want to assure your customer gets the best deal. You want to create an incentive for the customer to enter into the agreement. You want to cut your customer's costs, which can theoretically be passed from the buyer downstream. And you want to guarantee to the buyer that even if the price that the buyer pays increases, the other buyers will not have a price advantage over it. Now, a seller can circumvent these limitations by adding language that makes the most favored customer applicable to customers that only purchase similar qualities or of similar goods based on similar terms and conditions. Again, if you're given a customer, distributor, or similar agreement with one of these and you're not a beneficiary, delete it. You do not want to be locked in to having to provide any customer with the lowest problem. What it does is create a race to the bottom. You have to lock in your retail prices, so you're not incentivized to make improvements to your products that will increase your costs because you can't raise your prices. So instead of trying to innovate and continue to strengthen the product, you end up taking steps that are as cost effective as possible. You know, the key here is if you see a most favored customers clause and you're not the beneficiary, delete it. On the other hand, if you're going to get this clause as a customer, take it. You know, the inverse of this concept is true. If you can get a most favored customer clause, you'll have a fixed clause no matter what. And again, it'll all be fact specific and dependent on the license. But if you can get this, I would recommend taking it. Now, at the end of the day, most parties who include these kind of provisions in their agreements won't expect you to agree to any most favored customers clause, and they usually have it in there as something that they're willing to give away quickly so they can get something else in the negotiation. Yeah, Susan, again, is it a typical term? I wouldn't say it's atypical. It really depends. It is much more for manufacturing. You know, something that a very famous case when Apple was entering the ebook space, they introduced a most favored customer clause with all the producers of ebooks, so they could set prices to compete with Kindle. And they actually at that time ended up having the courts find that they were using the most favored customers clause in a way that was anti-competitive, and they were forced to settle for several $100 million because their most favored customers clause was seen as conspiracy to price set within the ebook industry. So to your question, is it a typical term in tech? It's not always likely to see it, but if it is included in your agreement, at the end of the day, usually they have that kind of agreement in there so they can give it up and get something else that they want. Next slide, please. Good question, Susan. So we've gone over a lot of information today. Each of your businesses is different, and each contract you enter into has many moving parts. Not all the information we've gone over today will apply to every one of your contracts every time. What we're trying to do is give you an overview and to make sure we reiterate some practical pointers that were discussed today. So first, the big four of protecting your assets: ownership rights and license rights, confidentiality, assignment restrictions, and most favored customers. Pay closest attention to these sections when you're thinking about how to protect your assets. Next practical pointer: start with your own paper. If you can get the other side to agree to start with your agreement, you can spend a lot less time worrying about what's going to be in the contract because you will already know. Having good form agreements and the right legal counsel to draft those agreements can be the difference between a clean exit and a missed opportunity. Next practical point: just saying you own it doesn't mean you actually own it. Remember, owning technology is not like owning furniture. It is important to use precise language when dealing with intellectual property. Next practical point: the wrong license can give up practical ownership. If you give out a license that is exclusive, perpetual, and irrevocable without any carve-outs, you may be giving up practical ownership of your IP. It won't matter if you own it if you can't sell it. Next practical point: make sure you can assign the agreement in the event of change of control without consent. If you make certain that you have the ability to assign your contracts before you get to the diligence stage, you won't have to scramble for signatures when it comes time to close your sale. Next practical point: no NDA, no meeting. You need to protect your confidential information to ensure what you consider as a trade secret gets the legal status of being a trade secret. Without confidentiality, you may lose your special sauce before you get a chance to really start cooking. And finally, most favored customers. If you're the beneficiary, take it. If you're not the beneficiary, delete it. Again, this is the least contentious of these big four provisions, and likely is sent in and put in an agreement knowing that it'll be removed so they can use it as a negotiating chip. Next slide, please. I want to thank everybody so much for listening to me today. I'm happy to answer any additional questions you may have. This is my contact information. Please feel free to send me an email or give me a call if you have any other questions or if I can ever be assistance to you or your company. And at this time, I'm happy to open it up to questions. Yeah, you're very welcome, Rahul. Thank you, everybody. I really appreciate it.
Well, should we talk about what's on for our next session? We have on March 23rd, same time, 10 a.m., Protecting Your Business Restricted Covenants. And that's presented by Mary Claire Smith, who is an attorney in our group. So don't miss that one. There'll be more very good pointers for you. And then the last of the series is an exciting fireside chat with one of our clients, and I'm sure a company you know, because they're a villager, AsureSign. Courtney Schickel, who's the Chief Revenue Officer, will have a fireside chat. So please join us again for the rest of the series. You'll see and hear a lot of important tips.
And Anna, it seems like Susan asked another question. As a startup going to market, what would you say are the top 3 contracts or docs that we need? You know, I would be a bad lawyer, Susan, if I didn't say it depends. You know, if it depends on what stage of startup that your company is. You know, if you haven't incorporated yet as a legal entity, I would say that the most important top 3 contracts for you to get into would be your LLC operating agreement, you know, or ensuring that you have the board consents, articles of incorporation. You know, there's certain documents and contracts that you need in order to be a legal entity. So if you haven't incorporated yet, you know, those incorporation documents are most important. And then as far as, you know, your top 3, you know, moving forward past the stage of incorporation, it would depend on what your product is. Are you a development company? Are you a SaaS, offering a SaaS product? You know, I will say, you know, having a strong NDA is something that's very important for any startup. You want to make sure, as we reiterated, that you have any of your confidential information protected for anyone that you have, any potential customer or distributor or provider that you are talking with. So I say that would be number 1 after the incorporation, is making sure you have a strong NDA. And then after that, it all depends on what it is your product is that you're offering. You know, for a SaaS product, having a good MSA, terms of use, privacy policy is important. You know, as a contract, if you're offering a developer, if you're a development company, you know, making sure that you're able to have a strong, you know, independent contractor agreement. You know, it's hard to know exactly how more to answer that question without knowing exactly where your company is located. And again, feel free to, thanks, Susan. Feel free to email me if you have any questions. All right. Well, if that is, if you have any other questions, please, again, feel free to reach out to me. And I appreciate you guys taking the time today to learn about protecting your assets. And I hope you have a great rest of your day.